They came back to us and said that Mr. Reyes' office had informed them that they were refusing to attend the mediation.
Okay. All right, Mr. Ray, response?
Thank you, Judge. You have access, respectfully, Judge, do you have access to the listed exhibits?
I do.
Okay. In anticipation of this challenge, again, if we can refer to Petitioner's Exhibit 29, it is our email on March 3rd to the DRC with our mediation request form, including the necessary documents. That was on March 3rd, which, if you'll remember, Judge, March 11th was our hearing date. Mr. Anderson had not properly e-served his appearance of counsel on us. That I believe was filed on the 24th or 26th. And when we finally learned of his involvement, we realized that on March 3rd, we had served her directly instead of Mr. Anderson. And I think we addressed that sufficiently on March 11th, the last time we were here. On March 11th, we had our hearing. And Judge, if you remember, you identified and kind of gave us the estimate that the fees associated with the DRC would be $50. And based upon the parties' resources, that was a splendid cost. What we learned at that hearing was that Mr. Anderson specifically stated that he had Ms. Rawas's financials and would deliver them to us shortly. That did not happen. But we do see that her financial information statement was, and this is exhibit number 34, Judge, that her document was signed on March 2nd. So he did have access to it, but waited until 8:33, the morning of mediation, to deliver those. And the pay stubs at 8:48. We put the times on our exhibit list, Judge, just for some clarity. More specifically, the day before mediation on April 6th, we learned from the DRC that Mr. Khalaf's portion was going to be the max amount allotted of $350. That was nowhere within our realm of possibilities with regard to that. So yes, immediately, based upon the fact that there were no required disclosures sent within a month of being due, no financial statements or recent pay stubs that counsel had detailed that he had access to and would send until the morning of, and the real issue with the cost that was not anticipated at all by any party here, we did cancel. Yes, Judge, based upon absolutely no communication with Mr. Anderson until the 11th hour. Again, if you'll remember that, Judge, there were motions and things filed on the 11th in the middle of the night. We entered this order from March 11th without Mr. Anderson's signature, because between the hearing on the 11th and the email at 8:33 on April 6th, Mr. Anderson did not communicate. Period.
If I may.
No, I'm not finished, Judge.
Oh, okay.
So he may not.
Mr. Ray, hold on. Mr. Reyes still has the floor, Mr. Anderson. I'm going to give you an opportunity to respond.
Thank you, Your Honor.
And that morning of mediation, yes, the DRC did reach out to us, Judge. We went back and forth with them trying to determine the cost of mediation. We had scheduled and said, look, we'll appear at 10 o'clock once we get everything situated. Ryan, who took 3 or 4 phone calls to actually identify his first name, finally said, hi, I'm the mediator. My name's Ryan. Mr. Khalaf will pay $65. And we're like, you know what? To do this, we are happy with $65. Then he comes back on the next phone call and says, no, it's going to be $350 because of the financials are filled with issues of they are just erratic and don't make sense. And he didn't send his most recent pay stubs. He's a 1099, so there are no pay stubs. And his most recent tax return, I think they were looking for the 2020. And remember, taxes are not due until April 15th, and I believe it may even be May 15th this go round. He only had a 2019, which we sent to them. And just as an aside, Ms. Rawas had that document as well. She has access to these documents. Mr. Anderson has access to these documents. But Judge, it's accurate. We canceled mediation because of the many issues with communication, documents to support, because if you remember, we were hoping to be able to prepare and have some issues addressed before today, knowing that conservatorship was likely going to be the main issue. Despite sending previous settlement offers, I've heard nothing back from Ms. Rawas when she was pro se, and Mr. Anderson as her attorney of record. But yes, we did cancel, Judge, because it was going to be it was an absolute farce about how we were trying to figure this out. The lack of communication, the lack of providing the necessary documents and the required disclosures were just too much of a barrier to waste hundreds of dollars after all of the money that Mr. Koloff has incurred and spent on this matter. And the court remembers that we've been here 3 or 4 times on emergency motions, and it just got to be a little too much, Judge, and too much for Mr. Koloff to be the bearer of all of these costs with absolutely no light at the end of the tunnel because of the lack of communication and lack of the provision of the documents.
Thank you, Mr. Rea. Mr. Anderson, brief response.
Yes, Your Honor. Issues with communication. I thought that the Dispute Resolution Center would provide the financials to him. We forwarded those to the Dispute Resolution Center. They didn't provide them to them. If they had requested we provide them to them, we would have. That's why I sent them immediately after I saw the email saying that they weren't appearing for mediation because they didn't have her financials that were provided to the DRC. Now, those financials are her basic 2 pay stubs and a brief specification of her pay. She left with nothing. So the statement that she has access to the tax returns, she left with the children and nothing. She doesn't even have most of her clothes, any of her shoes, any of her wardrobe. She left with nothing. So he said that the prior filing was done in the middle of the night by me. Yes, it was, because the incident had just happened the day before. So that was my prior filing for the emergency motion, which we didn't hear. If he had requested that we provide him the materials, we would have. I sent the materials to him immediately upon receiving the notice that they weren't appearing. He says he's not received any response to a settlement offer. The settlement offer was basically Mr. Koloff keeps everything.
I will object.
Your Honor.
Reference to settlement offer and the specific terms therein.
Okay, granted.
Hold on, Mr. Anderson, you can respond to his statement that you didn't respond to the settlement negotiations, but I don't want any details of what the settlement negotiations were from.
My statement with regards to the settlement offer was I thought we could mediate the situation and come to some resolutions. Now, he says he doesn't want to waste any more time or money because we've been here 3 to 4 times on emergency motions. The emergency motions which have been filed by his client, which have been in relation to, does the child have FaceTime? Does the child this? I filed an emergency motion where he refused to return the children the day before. We didn't hear that, even though the motion was filed. Why? Because it was too late. Recognizably. What I'm saying here is I think mediation could solve a number of these issues, and we could come to an agreement on a number of issues, thereby sparing his client further expense, sparing my client any further expense, and avoiding the issues involved in such matters with the court. That way we can structure the temporary orders around the results of said mediation, and we can come to some solutions, as opposed to sitting here wasting our client's time and the court's time. Now,
Thank you, Mr. Anderson.
mediation,
Go ahead.
they sent us a bill for $350. Okay, now it turns out it was an error, but the initial bill that we received was $350. I forwarded that payment on behalf of my client so we could go ahead and pursue the mediation. That payment was made in full. Why? So that we would get before the mediator. I didn't even know that that was a mistake until after we had entered into the mediation. Okay? Once we entered into the mediation, he asked why we paid $350. I told him that's the bill that you sent. He said, oh, that's a mistake. You were actually only supposed to pay $65. Wonderful. Why? Because my client has just started a job. But in the interest of avoiding wasting my client's time, money, the court's time, Mr. Kalof's time and money, I thought mediation would be the best result for everyone. My client thinks the mediation will be the best result for everyone, so that we can come to some agreements. That way the temporary orders can be properly structured around something.
All right, thank you, Mr. Anderson. So here's my issue as a judge. I'm a big proponent of mediation. I was a big proponent of mediation as a lawyer. I'm a big proponent of mediation as a judge. But that being said, I also am, I think there's got to be stability for, 4-year-old and 2-year-old kid, that when we have parents living in multiple states and there's no orders, that's a very chaotic environment for both of these parties and for those children. And so that concerns me as well. So I'm going to go to Mr. Rea and ask him because there was some testimony previously where there was an issue where Mr. Rea was trying to get mediation waived, and I denied that, and I ordered y'all to mediate. Mr. Rea didn't feel like mediation would be fruitful. There was a little bit of testimony provided that did concern me, that it might be difficult to get this case resolved at mediation. But I was optimistic that perhaps something would come out of mediations, because we've all been in those mediations where we think this is going to be a complete waste of time, and we get in there and we end up getting the case settled, and vice versa sometimes, where there's no reason for the case not to settle and then ends up going to trial. But Mr. Rea, would there be any harm from your perspective? This case has been pending for 2 months. Y'all been trying to get temporary orders hearings. So I'm inclined in some ways to just hear this today. But I do agree with Mr. Anderson that if these parties can put their heads together and come up with some kind of solution where they are actually in control of getting that order, that may be more beneficial for them than everybody duking it out today in this temporary orders hearing. Mr. Rea, do you have any issues mediating, or are you of the opinion this case needs to be heard today?
Judge, I've mediated for 10 years, so I have had moments where it's like an onion, where you got to get 3-4 layers deep until you find the real issue of the matter, and then you finally get there, and then things start becoming fruitful. As discussed at the last setting, the integral issue here is where the children will reside, and I don't believe that the parties are anywhere near a similar stance on that. Of course, we could have stipulated to property and these kind of issues, but I've not communicated any at all with Mr. Anderson, because I've got no responses. Those were all terms, as you can imagine, of a full-fledged settlement offer with no response. So we could have done some of these issues that Mr. Anderson identifies as likely outcome from mediation, but we've not been able to discuss them in a fruitful way. I don't.
All right, that's good.
Okay.
I'm of the opinion that this case has just been pending for too long. I think we need some orders in place. That being said, this is a temporary order. This is not a final trial. So I am going to put y'all on a clock today because I find that when I don't, sometimes I get the same information over and over, or I get redundant witnesses that are telling me the same thing and not really adding anything new. I have to close today at 4:30 because I have an issue that I've got to shut down at 4:30, and that's just something that the court, normally I'll go till 5, but today I've got to end a little bit early. And so what we'll do is, if I give each of you, I'm going to give each of you 2 hours and 15 minutes. I'm going to put y'all on a strict clock, which means when you're cross-examining someone, you're on the clock. When you're direct examining someone, you're on the clock. When you're giving me opening statements, you're on the clock. So just keep that in mind. And I will give y'all updates occasionally. I try not to interrupt testimonies. Normally I try to do that after a witness is passed. But if I feel like we're really getting bogged down, I may interrupt you and say, look, this is where you are on time, because I know as lawyers, sometimes we lose track of, we get in the heat of the moment and we forget that we're on the clock. So each side is going to have 2 hours and 15 minutes. And with that, we're going to get into the temporary order series. I know there's a motion to compel on file as well. It looks like that would take about 3 minutes from my reviewing the motion, but I want to get into the temporary orders to make sure we get that done, because the motion to compel is less urgent from my standpoint, and it's something that we can address on another day if we don't get done with if we have to use all our time today to do the temporary orders. So with that being said, Mr. Rea, you're the filed first and represent the petitioner, so you're going to be allowed to present your case first, and then Mr. Anderson, you'll be able to give your case next. And we're going to start the clock now. Mr. Rea, you may give your opening statement.
Thank you, Judge. As the file before the court, you'll see that a petition for divorce was filed on January 4th, 2021. This was based upon Ms. Rawas fleeing Texas based upon some allegations of family violence. Subsequently, applications for protective orders regarding her and the children were filed in Missouri, both which were dismissed after hearing and a trial on the merits for each. The testimony in the—
I object, because it wasn't necessarily dismissed for on the merits. They were dismissed. That's all.
I said after the trial on the merits.
Hold on. Wait. When there's an objection, let the court get a response out, because we've got many taken down the record, and it won't take down two of us talking at the same time. I know it's difficult with Zoom, but give me the courtesy of ruling on my objection before responding. If I need argument on the objections, I'll always ask for that. If I don't need it, I'm just going to rule. But the objections are ruled. Mr. Ray, you may continue.
Thank you, Judge. The parties have lived in Texas for nearly 9 months, and Texas is the home state of the children. There's no dispute in that. The court will see evidence regarding the necessity for the children to remain in Texas and in their home that they've grown up in for the last 9 months. It's necessary for Mr. Koloff to be the primary conservator. It's necessary for Ms. Rawas to have a relationship with the children. The parties will ultimately be able to work together on this, but the court's decision today is to determine what is in the best interest of the children, and the evidence will show that Mr. Koloff is the party and the parent who will be able to communicate with Ms. Rawas and work together with her and co-parent. The issues before the court will be where the children should live, what sort of possession and access each parent should have, what sort of child support obligation the children should have, along with the issues of medical health insurance and dental insurance for the children. Furthermore, the issues with property of use of property, those will be issues before the court. And as the council has stated, it's clear that that will not be a real integral issue, as the parties don't have much property at issue. Judge, the evidence will show that the children should remain with Mr. Koloff, residing here in Fort Bend County, and that will clearly be in their best interest. Nothing further.
Thank you, Mr. Rea. Mr. Anderson, would you like to give your opening at this time?
I
Or
will.
you can wait for your case in chief.
I will pass to my case in chief.
All right, let's have Mr. Koloff and Ms. Rawis, if you would please raise your right hand to be sworn. Do each of you solemnly swear or affirm the testimony you're going to give in this call will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, Your Honor.
Thank you,
Thank
Judge.
you. Mr. Ray, you may call your first witness.
Thank you. For housekeeping, Minnie, we are on one speaker, so if you hear a bunch of feedback, just wave me down and we'll figure out what some issues are. I would like to call Mr. Koloff.
You may proceed.
What is your full name?
Ziad Kalaf,
What is your relationship to Reem?
husband,
How long have you been married to her?
5 years,
What is your relationship to Amir and Majida?
father,
And how old is Amir?
2 years,
How old is Majida?
4,
Where do you reside currently?
Rosenberg, Texas,
Who all resides with you there?
my kids and my parents.
Okay. Can you describe that house for us?
It's like 2 floor plan, 4 bedrooms, 2.5 bathrooms, front and backyard.
Okay. Who sleeps in each room?
So my older son and my little son sleep together, and my daughter sleep with me, and my parents sleep in another room.
Okay. Are Amir, what's your other son's name?
Fathi,
And is he a child of this relationship?
no,
And are you the primary conservator of your son Fatih?
yes,
Do Fatih and Amir sleep in the same bed?
yes,
Okay. And they're in their own room?
yes,
How old's Fatih?
9 years old,
Okay. What grade is he in?
3,
And Majida, does she have her own room?
yes,
But sometimes she sleeps with you?
yes,
And how old is she again?
4.
How old are your parents?
My father 70 and my mother 58.
Okay. Do you own this home?
My parents owning his home, yes.
Do you remember filing our original petition on January 4th, 2021?
Yes,
Do you recognize do you recognize petitioners 9,
yes.
Judge, should I share the screen or reference it and let everybody look at it on their own?
You can do whatever you prefer. I've got it in front of me, so when an exhibit is entered into evidence, I can review it on my monitor. But if you need it for the witness, you can certainly share your screen. I've given both lawyers permission to do so.
I have a hard copy for Mr. Koloff of the exhibits that will be tendered to the court. Mr. Koloff, do you recognize the supporting affidavit that you signed on January 4th?
Yes,
If I asked you questions about that information included in the affidavit, would your answers be the same as what was stated in the affidavit?
yes,
Judge, I'll offer petitioner's exhibit 9 as a shorthand rendition of Mr. Koloff's testimony.
Any objections to petitioners 9, Mr. Anderson?
You're on mute, Mr. Anderson.
Did you second the motion?
Apologies for having him muted. Do I object to the admission as his affidavit? No, I don't object to the admission of the affidavit. Do we have differences with what's included? Certainly, but we don't object to its admission at the time.
Understand, P9's admitted.
Do you recognize Exhibit 23, Petitioner's Exhibit 23, our relief requested?
Yes.
If I were to ask you questions about what you're asking the court with regard to these temporary orders, would your testimony be similar to what's included in Petitioner's Exhibit 23?
Yes.
Judge, I'll offer Petitioner's Exhibit 23 as Mr. Khalaf's shorthand rendition of his relief requested.
Any objections?
Don't object to the admission as that's his requested relief, Your Honor.
P23 is admitted.
Mr. Khalaf, when did you and Reem get married?
April 2015.
Where did you live when you get married?
I'm sorry, 2016.
Where did you live when you got married?
Lebanon,
How long did you live there?
6 months.
Were the children born there?
No,
Where were the children born?
in California, US.
When did you move to California?
November 2016.
How long did you live in California with the children?
3 years,
When did you move to Texas?
April 2020.
When you moved to Texas, did you move to the same house you reside in now?
Yes.
Does Reem still reside at this house?
No,
When did she leave?
December 23, 2020.
And did she live there until she left?
Yes.
How long had the children lived in Texas before Ms. Rawas left?
9 months.
Did she leave with the children?
Yes.
Did she have the car seats
No,
in the car when she left the house?
no.
How did she leave the house?
So she called Uber, and while the CPS officer investigation me, she took the kids and the luggage and left the house without notice.
Okay. Did you know that she was leaving for good?
No.
Okay. When did you learn of Reem's new location?
Like after like 3-4 days.
Okay. How did you find that out?
I know that she booked a ticket to Missouri, and the friends in California, we have a friend in California, they notified me that she is in Missouri.
Okay. Did she ever tell you where she was going?
No.
Did she ever tell you where she was when she got there?
No,
Did she ever let you communicate with the children?
no.
When was the beginning on the day she left on December 23rd? When was the next time you had any sort of contact with your children?
February 11th.
Why did you have some access to your children?
Why I have? Like, because I am the father and I need like to have a contact with them.
Had you tried to contact the children before that?
No,
Okay. Did it take a court order for you to get some contact with the children?
yes,
Are you aware that Reem filed an application for protective order against you to protect her in Missouri?
yes.
How did you learn that?
I served in January 12th.
Um, Did you review the application the lawsuit was based upon?
Yes.
If I showed you petitioner's exhibit 10, would that be the document that you were served with?
Yes.
Okay. So this is the document that's the petition for order of protection for an adult.
Yes.
Judge, I'll offer petitioner's exhibit 10 as the document that he, as to the court.
Any objection to P10? Mr. Anderson. Mr. Anderson, you're muted. Objection to P10?
Yes.
Mr. Anderson, what did you say?
Any objection to P10?
B10? Not at this time, Your Honor. Not to the admission.
All right, P10 is admitted, and Mr. Ray, I see there's a P10.1 as well.
Yes, Judge.
Are you offering P10?
Not yet, but yes, it's a separate exhibit, Judge. Identifying them get weird when you start squeezing them in between ones. Did you review the application when you were served?
Yes.
Did the application include an affidavit from Ream?
Yes.
Was it accurate?
No.
Why not?
Like, because all of the affidavit is not true. Like, nothing happened like what she's saying in the affidavit.
Yeah, that was not true.
Was it are you aware of a Missouri protective order regarding protecting your children
Yes.
from you as well? If I offered, or if we looked at petitioner's exhibit 10.1, would that be the document regarding the protective order for the children that you were served with?
Yes.
Judge, I'll offer petitioner's exhibit 10.1.
Mr. Anderson, any objection?
No, Your Honor, not at this time.
P10.1 is admitted.
Ms. Zayed, do you recognize that each of these applications include the same affidavit?
Yes.
And when we refer to the affidavit, it's the same one in both. Was it accurate?
No.
Okay. Why not?
So, because in the affidavit, Reem accused me that I tried to kill her and the kids 3 times. I punched the kids. I slapped the kids, left blood marks, and nothing from this happened. Some of these affidavit is it true, but it done from Reem, not from me.
Was there a hearing based upon the application regarding Reem?
Yes.
Was there a hearing regarding the application for protection of the children?
Yes.
Where was that hearing set? Location?
In Missouri.
And did you appear in person?
Yes.
Did you hire an attorney?
Yes.
Did Ms. Rawas have an attorney?
Yes.
And who was that attorney?
Mr. Anderson.
Okay. So both of you were represented.
Yes.
And when was that hearing? Do you remember?
Sure. February 10th.
And did the court deny Ms. Rawas's application with regard to her application for protective order?
Yes.
Did the court deny her application for protection of the children?
Yes.
And did each matter have a hearing?
Yes.
Did the court consider testimony and evidence regarding each application?
Yes.
And denied and dismissed both applications?
Yes.
Did you learn anything at the hearing that concerns you?
Yes.
Did Reem admit to being the person to abuse you?
Yes.
What did she say at that hearing about abusing you?
So she admitted that she spat on me. She's screaming, shouting in front of the kids, in the front of the judge in Missouri.
And the court dismissed the case, right?
Yes.
Judge, I'll offer Petitioner's Exhibit 11. Judge's housekeeping. You may have bookmarks, which may allow you to bounce around a little easier. I'm not sure. Do you recognize Petitioner's Exhibit 11?
Yes.
And is this the order regarding the application for protection of Ms. Rawas?
Yes.
And is this the order that states that her motion that the motion to dismiss was granted?
Yes. Yes.
And that the case was called, parties appeared, and case dismissed for failure to state a cause of action?
Yes.
Judge, I'll offer Petitioner's Exhibit 11.
Any objection, Mr. Anderson? Mr. Anderson, you're muted.
No, Your Honor. I recognize that the motion was dismissed. That's fine.
The 11's admitted.
Do you recognize Petitioner's 11.1?
Yes.
And do you recognize this as the order regarding the children's protective order?
Yes.
And Judge, I'll offer Petitioner's Exhibit 11.1.
Mr. Anderson?
I believe it's regarding the children's. Give me a second. No objection at this time, Your Honor.
The 11.1 is admitted.
Did law enforcement ever visit your residence?
Yes.
Did the Rosenberg Police Department make a report?
Yes.
Judge, I'll offer Petitioner's Exhibit 22, which is
Any objection?
as a business record affidavit, Judge.
Any objection, Mr. Anderson, to P22?
No objection to the admission of the police report, Your Honor.
P22 is admitted.
Mr. Kaloff, you referenced CPS earlier. Did CPS ever visit your residence?
Yes.
Did CPS perform an investigation?
Yes.
Did CPS complete their investigation?
Yes.
Judge, Mr. Kaloff, do you recognize Petitioner's Exhibit 21? You
Yes.
recognize 21? Is this the letter that you received from CPS?
Yes.
And is this a detail of the allegations?
No, I just like ruled out.
But in the second column of the table, does it show what sort of
Oh,
allegations happened?
Yes, it is a neglectful and physical abuse.
And does it identify each individual child?
Yes.
And what are the findings on each and every one?
Ruled out.
Okay. Judge, I'll offer Petitioner's 21.
Nope. I know I'm muted. Oh, no objection, Your Honor.
P21 is admitted.
I think I interrupted him.
We identified that a full hearing was held on Ms. Rawas's application for protection of the children, right?
Yes.
Didn't Reem admit to spitting in your face?
Yes.
Did Reem admit to striking Majida for
Yes.
having a bathroom accident?
Yes.
Have you ever seen Reem spank Majida?
Yes.
Did you have to interrupt Reem to stop her spanking Majida?
Yes.
Why did you have to stop her?
Like to save the kids.
Save
save
them
my-
from what?
Like she slapped my daughter for doing something. It's like out of control. She's like too young. It's not the first time. Like I asked Reem like to not do this, to not like screaming in the kids, because these things like happen with any kids, and like it's not the way like to teach the kids or to say to the kids when you will understand. They are too little like to say when you will understand.
So what is Ms. Rawas's regular form of discipline?
Can you explain more?
How does she normally discipline the children?
Okay, so this accident happened like when my daughter's 3.5 years. So she was playing in the game room. She accidentally like do it in herself, like pee. And Reem went to the playroom, and it's not the first time. She slapped my daughter 3 times. She started screaming on her. I was downstairs. I went upstairs, like to save my daughter, and I asked Reem to not do this to my daughter. She said, when she will understand. I said, it's too young to say this to my daughter because she is 3.5 years. And she said, no, she understands. And she told me, okay, then teach her how to use the bathroom. I said, okay, but if I slap my daughter, I will not teach her to use the bathroom.
Do you have a concern about how Ms. Rawas disciplines the children?
Yes, like for example, also when this argument happened in December 20 and 21, she tried like to separate my older son from the kids because as I said, the kids was sleeping together. And in December 21, she took the 2 little kids to sleep upstairs, and she denied my older son to sleep with them. I promised, like I asked my kids that next day you will sleep together. And then the next day she fled to Missouri without like having the kids together.
Did she regularly yell at the children?
Yes, and it's not only for my 9 years old, even it's like for my 2 years old. If he's doing like something like playing or like throwing like water or something in the floor, she's like yelling on him and like put him in the naughty corner or like this, but he is like too young.
Are your parents usually around
Yes.
the house? Does it maybe wear on Reem to have her in-laws there with her?
Yes.
Has she ever yelled at them?
Yes.
Okay. Do you have a concern that the children don't get to use car seats while in Reem's possession?
Yes.
Why is that?
Because when she left Texas to Missouri, she didn't took the car seats with her, and then my daughter told me that she didn't use a car seat over there.
During the time that they were there.
And, yeah.
So they.
Your Honor, I object to what the child may have told him.
The objections sustained, but the
Yeah.
answer's already been answered. So I've heard that testimony, but Mr.
That wasn't a proper objection.
I'm sorry.
I object for his.
That wasn't a proper objection.
I understand. And the answer's already been answered, so we're going to move on. But don't tell me, Mr. Khalaf, in the future what your daughter said, and if you can help it.
Is it accurate that Reem left the marital residence in December without a car seat for either child?
Yes.
And isn't it accurate that her aunt and uncle attempted to pick up the children on March 9th without a car seat for either child?
Yes.
Have you taken a look to see how accessible a car seat would have been
Yes.
through the rental?
Yes.
Okay, Judge, I'll offer, or Mr. Galata, please take a look at Petitioner's Exhibit 19.
I don't have no.
Here, take a look. Let's share this.
Your Honor, I object to the admission of 19. It has no relevance to the case. The car that they were driving was a borrowed car. It was Avis or a Hertz or a budget rental.
Okay, well, he hasn't offered R19 yet. I think he's trying to lay a predicate, so objections premature at this time.
Judge, I believe the screen shows Petitioner's Exhibit 19. Do you see
Yes.
19? Do you recognize that this is additional car rental equipment from Enterprise Rent-A-Car?
Yes.
Is this a regularly available through your research
Yes.
of options for car rentals?
Mhm.
And are you aware what means did Ms. Rawas's aunt and uncle use to travel while here in Texas? What kind of car did they have?
Like mid-size car?
Was it their car?
No, it's a rental car.
Okay. Did they tell you it was a rental car? How'd you know it was a rental car?
Because they didn't have a car here and they came through the airport and the car is like a new one.
Okay. But when you look to see if car seats were available in rental cars, you found what?
I found this like a regular available with any like big agents like Enterprise, Avias, Hertz.
Okay. Judge, I'll offer Petitioner's Exhibit 19.
Mr. Anderson, any objections to P19?
Yes, Your Honor, I object to the admission of Enterprise rental car availability of child safety seats, as there's nothing establishing they were driving an Enterprise vehicle or any other rental vehicle.
Judge, I believe many
What's the legal objection? Mr. Anderson?
I object for relevance.
All right, response, Mr. Rea?
Judge, it's been relevant as Mr. Anderson has filed multiple pleadings regarding the issue of release of the children and providing the instruction to third parties with regard to protection of the children and what's in the best interest of the children, car seat availability, and the decision to utilize car seats is clearly a relevant issue for a 4-year-old and a 2-year-old.
I understand the relevance of a car seat, but the objection to P19 is sustained at this time. P19 is not admitted at this time.
Thank you, Your Honor.
Judge, real quick, Judge Shepard needs me for a quick minute. Can we take a quick break?
Okay, we'll take a 5-minute break.
Thank you,
For the
Judge.
record.
Thank you, Your Honor.
All right, the court's back on the record. We had a little bit of an issue. We've lost our court reporter for about an hour. Judge Shepard needs her, and that wasn't anticipated. But I've got the record going on the machine, so we'll be able to have a continuous record for the proceedings. Mr. Rea, you may proceed with your direct examination of Mr. Koloff.
Your Honor, if I may, right now, we're willing to stipulate that as part of a temporary order, we're willing to allow Mr. Koloff to have primary physical custody of the children. We have issues with visitation and things like this. While Ms. Rawas is more than 100 miles apart, but in the interest of conservation of time and resources, we're willing to stipulate that he be given primary physical custody of the children at this time.
Well, why don't I do this? Why don't I create a breakout room for the two lawyers? Because that's going to significantly cut what I need to address today.
Yes, sir.
And we'll save a lot of time. I think you guys might be able to make a lot of progress if I just put you all in a breakout room, because I don't want to hear the settlement negotiations as it relates to rights and duties and that kind of stuff. So I'm going to put you all in a breakout room. If y'all need me, there should be a button at the top of the screen where you can hit it, and it will, hold on a second. We're going to go off the record. You can ask for me to come in and I can join that room if y'all need me. Okay, but I'm going to create a breakout room for y'all at this
This
time.
is one of the reasons why we were more interested in mediation, because I thought that we could make some significant progress on the case.
I understand, Mr. Anderson, and I was on the fence on what to do there, but and I appreciate your argument, but hopefully this will help save us some time. So let's do this.
Judge, I'll ask Mr. Koloff to leave. I think he's in my office and Ms. Rawas is with Mr. Anderson. So,
And you can keep your clients there. There's no problem with that. But if y'all need to, if the lawyers want their clients there, because you're going to need their authority for anything y'all do. I just don't want to be a part of it.
understood.
So, all right, I'm going to put y'all in that room. Thank you.
Thank you, Aaron.
Judge.
And you can stop your video, Mr. Koloff, so I don't see what you're doing. Or I'll just put you in that room as well. Well. Okay. Should stop streaming now. My body's finally getting used to working out again, I think. It's pretty cool though, this thing that I go to, it's they always have different, like every time I go, it's different exercises, and it's, you know, like a full body workout.
Yeah.
And a lot of this junk I've never done, like putting one leg back and, you know, on a bench and doing a one-legged squat, and then you flip, and I'm like, it's kind of dangerous with an
Yeah.
old man my
Yeah.
age, because you know, squatting with on two legs is difficult enough. But it's cool because I mean, I noticed, man, I'm getting sore in areas that you know, I wouldn't normally get sore in. And but yeah, I just wish I could fix my shoulder. It's got a bad shoulder, and I need to probably go ahead and look at that. But it's been fun. I'm kind of enjoying getting back in the weight room.
Is it outdoor thing or is it indoor?
Indoor.
Indoor? Yeah.
All right, have a good lunch.
Okay. See you.
Judge, I think you're not muted. David, I just heard some chairs moving around, so maybe they're close.
Okay, so how turn on my?
All right, we're not on the record yet, gentlemen, but I just kind of figure out where we are and what y'all think, and then we'll get on the record and make announcements. But have y'all made any progress over lunch?
Yes, Your Honor, we have.
Are y'all ready to put those agreements and stipulations on the record?
I believe so, Judge.
All
Is
right,
that
the
accurate?
court's back on the record.
I was just confirming with David, Judge.
Get some feedback, Mr. Rea.
Mute. No, I need to make my.
I got it,
The
Judge.
court's back on the record. The court's back on the record in cause number 21 DCV 279680. We broke for lunch, but right before breaking for lunch, the lawyers had entered into some negotiations, and it's my understanding there's been a few agreements reached during our lunch break. Which lawyer would like to recite those agreements into the record, and then I'll ask opposing counsel if that's their understanding of the agreement. Mr. Rea, do you want to do that?
Judge, I'm happy to. Judge, I'll refer, and Mr. Anderson, correct me if I'm wrong. I'm going to refer to Petitioner's Exhibit 23 for some of the basic terms. Judge, may I?
You may proceed.
Thank you, Judge. Judge, it is my understanding that the parties are agreeing to be appointed joint managing conservators of Majida and Amir Khalaf as described in the rights and duties within Petitioner's Exhibit 23, relief requested temporary orders. Specifically, that Mr. Khalaf will be the parent temporary joint managing conservator with the exclusive right to designate the primary residence of the children within Fort Bend County or counties contiguous thereto, and the following rights and duty as described in the following sections. Furthermore, the parties have agreed that Ms. Rawas may have the right to possession in the following manner. Beginning on May 17th at 10 a.m. until later that day at 7 p.m. She will also have the ability to pick up her items that remain at the home. The parties have the ability to utilize a civil standby to ensure that nothing at odds occurs. Subsequently, Ms. Rawas will have the right to possession of the children beginning on May 31st and ending on June 17th. Again, her period, she will have the right to possession beginning August 3rd to August 17th. On the 2 periods just described, Ms. Rawas will pick up the children, excuse me, from the marital residence, and Mr. Khalaf will pick up the children at the beginning of his period from the residence in O'Fallon, Missouri. Ms. Rawas will have the right to possession of the children per the standard possession order holidays. We are specifically leaving the terms regarding travel up for future discussion by either mediation or the court. Mr. Khalaf will have the first half of Christmas in odd years. Ms. Rawas will have the Thanksgiving holiday in odd years. Ms. Rawas will not pay a specific amount of child support at this time, but Mr. Khalaf does not waive any back support or retroactive support, Judge. Furthermore, Ms. Rawas will have the right to up to 2 Tuesdays per month outside of the summer holidays, is my understanding, with notice to Mr. Khalaf the previous Thursday by 6 p.m. And each of those Tuesdays those periods of possession will occur in or about the marital home in Fort Bend County, Texas. Each of those potential Tuesday periods will begin at 8 a.m. and end at 7 p.m. And those pickup and drop off will be completed by Ms. Rawas at the marital residence in Fort Bend County, Texas. And Judge, I think all of this can be considered failing mutual agreement. These are the terms.
Ben, real quick, you said the visitation will occur in or around the marital home?
Just because
Fort Bend County.
just identify that it's a pickup and drop off from the home.
Yeah.
She can go as far as she can get back.
That's fine.
And then I need the possession schedule for May 31st and through June 17th and August 3rd through August 17th. I didn't hear start and end times. Is that 6 p.m. or is that a different time?
Judge, let me see. I can't remember. I think we said 4 p.m. pickup when Mr. Khalaf travels to Missouri. If I remember from our underlying order, I'm scrolling back.
His pickup would be 4, and hers, I mean, it's going to depend on travel time and everything else.
Will she be traveling in that particular day?
I think that she would be there the day before. She would be driving the day before and pick up that day. So yeah, the August 3rd is definitely that way.
Right. Those are both Mondays.
First is that
They're
So-
all Mondays.
3rd, that's the day that she's to pick the children up because she's driving the day before.
Should we just say 4 p.m. across the board?
No, because she's going to pick them up and she's going to leave. I mean, she wants to pick them up first thing in the morning.
Well, that's Memorial Day is the 31st. Would you want to kick
Okay,
it
May
first?
31st.
10 a.m. on August 3rd is reasonable. That's another period when the children are there.
8 a.m.
10 a.m. just to let them get up and at 'em.
Well, I mean, she's going to be driving with them all day. I mean, it's whatever, a 13-hour drive.
I think she's driving the same amount of time whether she starts at 8 or 10.
I'm just thinking about trying to get the kids to bed at a more reasoned time.
Why don't y'all make it 9 a.m.? What's the difference? I mean, they can always do something different than that time, but
Yeah.
I wouldn't argue over 2 hours.
Understood.
First, or no, May 31st.
May 31st is a Monday. And I can't go on Tuesday because I'll be driving on Monday.
Okay, the May 31st, that'll actually be June 1st. It won't be May 31st. She will be driving on May 31st. So she will be picking up on June 1st at 9 a.m.
9 a.m. Very good. And Judge, we are modifying the current terms regarding electronic access to within the window of 2 p.m. to 4 p.m. The parent not in possession will have the right to a 30-minute period of FaceTime, telephone, electronic access with the children. We have that as Sunday, Wednesday, and Friday, and then Mr. Anderson was going to determine if it was going to be Monday or Tuesday as that additional day.
What you want?
Can I just call them every day? And if I skip a day, it won't be a problem. No?
Could I have just a second, Your Honor?
May, just mute yourself, so, because we had a record going.
That'd be Tuesday, Your Honor. So Sunday, Tuesday, Wednesday, and Friday.
Got it.
Judge, I believe we discussed the part in the event the call is missed, that call be returned before the end of the window, being that 4 p.m., or the children go to bed.
But it's to be a little bit broadened so that if either party is unavailable, the call back before the kids go to bed.
That's fine, Judge. Medicaid will be through Mr. Kaloff in Texas, and that Ms. Rawas, if necessary, should withdraw any application for benefits in Missouri. With regard to injunctions, the standing orders that are in place, along with an injunction of, I guess, the instruction, I guess the injunction of not using safety seats or proper restraints, and an injunction against traveling outside the United States with the children. I believe that, along with Judge, Ms. Rawas is requesting that Mr. Kaloff return her passport. In the event it's in his possession, it will be part of the items that she picks up on May 17th. And then
Passport and social security card.
any personal documentation that he has, he'll corral and gather with that. And we also discussed that if Ms. Rawas has any paperwork regarding the children, that she would make a copy,
She will.
either through attorneys of record, so that and Mr. Kalak would do the same, so that each party has all necessary documents regarding that. And may I call, anything else, Mr. Anderson?
With respect to school, we didn't discuss this, but with respect to the school, just have her down so that she gets a copy of whatever the school sends.
And I referenced, Judge, I just remember this, Talking Parents, or our Family Wizard in our rights and duties. I believe Talking Parents is free. Our Family Wizard is $100 a year. I believe that if the parties would agree to communicating through Talking Parents, it would allow for them just to kind of maintain a good line of communication that we can kind of just keep track of.
Yeah, I think that's a good idea, and it's free to the party, so it doesn't cost them anything. So I know your rights and duties have our Family Wizard in there, and that was kind of what the stipulation was read into the record. But Mr. Anderson, if you don't have any objection, we'll change that stipulation so that it's the communications between the parties is through Talking Parents, which is an app that's free,
Yeah.
versus
No
our
objection.
Family Wizard, which.
No objection to using
All
Talking.
right. Mr. Anderson, does that accurately reflect your understanding of what the agreement is?
Yes, Your Honor, and we're going to be revisiting possibly mediation or further agreement by us prior to anything further going on, so.
And I'm going to let y'all each call your clients to verify this is their agreement. But before I do that, Mr. Ray, since you're the petitioner or represent the petitioner, you're going to be drafting this order. Do you want 4/23 for an entry date or 4/30 for an entry date?
Judge, will it be by submission? I'll be gone 4:30.
Yes.
Why I ask, and I've got 5 entries on 4/23. So I'm damned if I do, damned if I don't.
Why don't we can do May 7th if you'd like, but as long as y'all get the order in before that date, it's going to get signed by me, generally within 24 hours. So you want to do May 7th, or do you want to do it by submission on the 30th?
David, do you have any conflicts on either of those?
I mean, if you want to get it to me, we can do by submission on the 30th. I'm fine. I mean, I'll get it back to you as soon as I can, and we should be fine.
4:30.
All right, Mr. Anderson, Mr. Ray, I'm going to put it down for 4:30. If for some reason y'all have difficulty getting that order entered by that date, just email the coordinator and just get a week extension or something.
Thank you, Your Honor.
All right, Mr. Ray, if you want to call your client and confirm that that's his agreement for the temporary orders, and then Mr. Anderson, I'm going to let you call your client as well.
Thank you, Your Honor.
Mr. Kalas,
Yes.
did you hear those terms as described based upon a couple hours of conversation?
Yes.
Do you agree to those terms with regards to conservatorship, the
Yeah.
rights and duties, along with the possession and access? May I interrupt myself, Judge? I want to make sure that it's kind of a covering all of our bases, that Mr. Kalaf will have the children at all other times, not specifically designated for Ms. Rawas. I know that's kind of what we understand that, but with us being on the record, I wanted to make that clear. Mr. Kalaf, with the terms read into the record, did you understand them?
Yes.
Do you agree to those as to the conservatorship with the children living primarily with you?
Yes.
Do you agree to the terms that describe Ms. Rawas's right to possession and access of the children?
Yes.
Do you agree to not having a specific child support obligation payable to you from Ms. Rawas?
Yes.
And do you agree to those injunctions as described?
Yes.
Furthermore, do you agree that you may have the exclusive use of all the property in your possession, but for those that Ms. Rawas will be able to gather?
Yes.
And do you agree to pay for all the debts in your name that you are incurring while during the pendency of this divorce?
Yes.
Nothing further, Judge.
Mr. Anderson, any questions of this witness?
No, Your Honor.
Mr. Khalaf, I have one question. Do you agree that all these agreements that Mr. Ray has just asked you about are in your children's best interest?
Yes.
All right. Anything further from this witness, Mr. Ray?
No, Judge. Thank you for that clarification.
All right, Mr. Anderson, you want to call your client?
Yes, Your Honor. Could you please state your name for the court?
Dream Rawas?
And are you aware of all the terms that were just discussed?
Yes.
Are you in agreement with those terms?
Yes. Yes.
Is there any issue that we have not addressed at this time that is of particular concern for you, or are you in agreement with the terms as you've heard them?
I agree.
Nothing further, Your Honor.
Any questions of this witness, Mr. Ray?
No, Judge.
And same question to you, ma'am. You agree that these agreements are all in the best interest of your children, and you want me to approve these agreements?
Yes.
All right, the court has heard the testimony of the parties, and I want to say thank you to both lawyers for working during their lunch and getting an agreement on this case, as well as the parties. I know it's not easy negotiating these types of things, but I appreciate the work that y'all all put in. And I hope that this temporary order works out well for those children and for the two of you. But I'm approving all the agreements, finding they're in the best interest of the children. And we're going to set entry of this order for April the 30th at 9 a.m. By submission. If for some reason we don't get an order to Mr. Anderson in time for him to respond to the submission, then just, like I said, email the court coordinator and we'll give you all additional time, or we'll schedule the two of you a Zoom hearing for entry at a later date so that we can work out any issues. I would say that I want to use Texas Family Practice Manual language for everything other than these customized provisions. So if that helps the lawyers in any drafting disputes, that hopefully will give you all a little guidance on what my opinion is on it. Anything further that we need to address from either side before we go off the record?
Nothing at this time, Judge.
No, Your Honor.
All right, thank y'all. Y'all are excused.
Thank you, Judge. May we be excused? Oh, Judge,
May.
with regard to the DRC, it's not an automatic $50.
Yeah.
I don't know what happened over there.
Well, yeah, so I'll place a call into them. I made a note to do that after hearing what y'all said went down over there. So I'll find out what's going on because that first time I've heard of that. So I'm not sure what was happening there. Did you get Mr. Anderson, did you get a refund of everything from the 350 to the 65? Did you get a refund of the difference?
They refunded me the 350, but the 65 was still charged because I wanted the record that we had attended. If we didn't pay it, they would have said neither party.
Right.
What
I understand, and I appreciate trying to get that done. I know that they also, a lot of times they won't even schedule you on their calendar until they've got those financial documents. So I was also kind of surprised y'all had that date set, and it maybe it was because it was through court order with me, but before they had all the financial.
The resolution center the dispute resolution center had them, but they didn't share them with Mr. Ray. So I thought that they were based on prior experiences.
I know it just was pretty hokey, Judge, because it seemed like you were pretty confident in how it would kind of be coordinated. And out of the way that, just to kind of give you full disclosure, the way that they were calculating their fee structure is based upon gross income. So an individual who has a sales business, they look at that really top high number without considering cost of goods sold. So that was really the big issue. I was like, y'all are really looking at this in a very odd like way to calculate things. And I don't know if that's going to change anybody's way of doing it, but just so you know, if you're dealing with 1099ers who are small business folks, they may have, heck, they may be losing money, but it doesn't matter. It's going to look like if you're an oil exec or somebody that's just selling widgets, you may still be at 350. So that was more just making sure you kind of.
No, it's good to know that, and I will follow up and see what I can find out there, because that may impact what I do on cases where I feel like there's parties in front of me that might need a little bit of help. So I appreciate the input from the lawyers. Y'all have a good day.
Thank you,
Best of luck to you, Mr.